Welcome back to the video lecture on East Asia's cultural influence on the law of the sea. This time, we are going to speak on the United Nations Convention on Law of the Sea, the UNCLOS specifically. First, let us touch upon the case of China and Japan, and first we give to our eyes on the Chinese state practice. The People's Republic of China, the PRC of China, signed the United Nations Convention on Law of the Sea in December 1982 and ratified it June 1996. The third UN Conference on the Law of the Sea, let's say UNCLOS 3, was the first grand diplomatic conference to which the Chinese government sent a delegation after China, the PRC, replaced the Republic of China, the ROC or Taiwan, in 1971 for the seat of the Chinese in the United Nations. As a newcomer on the international stage, it was to be expected China might not have been well prepared for such a conference. During this period, China was highly influenced ideologically under the chairman of the Mao Zedong. The first 5 years of UNCLOS 3 they coincide with the Cultural Revolution, which is the period of the 1966 to 1977, a catastrophic era in Chinese history. During UNCLOS 3, the China seized the opportunity to criticize the perceived superpowers, the former Soviet Union and the United States, accusing them of their hegemony in the global ocean order, rather than focus on the constructive deliberations for its national interests in the detailed provision of this convention. China only submitted the conference 3 short working papers during the entire lengthy negotiating the period. As a prominent scholar observed, China had little involvement in and no expertise on the law of the sea matters at the time. The Chinese delegation sought instead to embrace the Soviet Union wherever possible and to maintain the ideological and political integrity of the G77 coalition. Nevertheless, the negative impact from the domestic politics gradually disappeared after 1978, when China began to implement economic reform and the open door policy. With the diplomatic pragmatism under the leadership of Chinese Deng Xiaoping, China paid attention to provisions in the draft UNCLOS which might not be favorable for China, such as the definition of the continental shelf. Yet it was difficult for China to revise these provisions during the final stage of the UNCLOS 3. Thus, on the occasion of the signing of the UNCLOS, the head of the Chinese delegation made a statement expressing disappointment with the provisions concerning the continental shelf and innocent passage. China maintains the ambivalent stance toward UNCLOS, acknowledging its imperfections while adhering to the underlying principles and norms, as well as the majority of its provisions. In the Chinese perception, the UNCLOS embodies the new law of the sea, the distinct from the old law represented by the 4 1958 Geneva Conventions, during which the People's Republic of China remained outside the UN system and unable to participate in the relevant international deliberations that resulted in the conventions. How about Japan? One of the most significant claims made by Japan during the UNCLOS was the maintenance of the 3 nautical mile territorial sea. This claim was based on Japan's interest in securing the freedom of fishing. Japan's 3 nautical mile territorial sea was established when Japan exported to Western powers in the 19th century. The claim to retain a narrow territorial sea and broad the high seas was based on the long history of fishing by Japanese fishermen within the area of the 200 nautical mile from the coast of other states. Therefore, during the first and second United Nations the Conference on the Law of the Sea, Japan insists that the area beyond the 3 nautical mile territorial sea should be the high seas, which belong to all human beings and where the all states enjoy freedom of fishing. In the 1960s, while international community increasingly expanded the territorial sea limit to 12 nautical miles, Japan still maintained a 3 nautical mile territorial sea and object to the establishment of the 12 nautical mile territorial sea by other states. In the early 1970s, Japan appeared to isolate from the rest of the world on this issue. Japan proposed alternate proposals at the 1971 Colombo meeting of the ASEAN-African Legal Consultative Organization. The proposal suggests that beyond the 12 nautical miles of territorial sea, coastal states that are developing countries could have priority access to fishing. At the Lagos meeting in the 1972, Japan submitted the proposal on the fishing regime of the high seas, which emphasized the priority of the coastal states, the fishing rights, and the importance of the conservation of the marine living resources of the high seas. However, this proposal did not gain support from Asian and African states because they prioritize the exclusive fishing rights within their own waters over priority access to fishing on the high seas with conservation obligations. During the third United Nations Conference on the Law of the Sea, the establishment of 200 nautical mile economic and fisheries zone by a number of states excluded Japanese fishermen from fishing within 200 nautical miles from the coast of those states and resulted in increased fishing by nationals of the other distant sea fishing nations such as then Soviet Union and Korea outside the 3 nautical mile territorial sea of Japan. The Japanese fishing industry faced the difficulties because its distant sea fishing in the 200 nautical mile zone of foreign countries amounted to more than 1/3 of its total catch. The Japanese coastal fishing industry also demanded government extend the territorial sea to 12 nautical miles for protecting against the larger scale fishing operations by foreign fishing vessels in waters off the coast of Japan. The Japanese delegation finally expressed its acceptance of the concept of the 12 nautical mile territorial sea in the Caracas session in 1974 and that of the 200 nautical mile economic zone in the fourth session in 1976 for the programmatic reason to protect its coastal fisheries. It was against this background that Japan promulgated new laws in 1977, introducing the 12 nautical mile territorial sea and 200 nautical mile fisheries zone. Japan signed the Law of the Sea Convention in 1987, but ratified only in 1996 when simultaneously revising the previous 1977 laws. Thank you very much for your attention.